if someone does not have an estate plan, if they could just have a will. Because remember, we are coming from a culture where your firstborn son would inherit. But in our African culture, you were not inheriting for your personal benefit. You were almost like an executor. You take over the family assets, you manage it, but for the benefit of the entire family. People must try not to have these wills written on your deathbed, because these are the wills that are usually the majority of the wills that are contested.
Welcome to the MAGC Wellness Podcast. I'm your host, Mrs Unopa Tarwa, and today we're going to be continuing with our topic of estate planning. And yet again, we are graced with the presence of Mrs. Tarwa. Mama, thank you so much for joining us.
It's a pleasure. Thank you.
And I would love you to reintroduce yourself to our viewers.
Thank you. My name is Unopa Tarwa. I am a practicing attorney in Nelspruit, specializing in estate planning.
Okay, so Mama is an expert. Ace, are we ready today?
I'm very much ready.
Are you ready?
Very much interested, and I have so much to ask. This is a very amazing topic, so yeah, I am very much ready.
Because these are uncharted waters. We're going to talk about serious, dangerous
things
today. I'm actually a bit excited, but also a bit anxious, because the things that we're talking about today are things that are affecting people on a regular, but they find out that they're important once it's too late, a lot of the time. Sure. So, Mama, can I just ask, in terms of strategies that people use in their estate planning, which would you say is the most important, like advanced strategies that a lot of people don't talk about?
Okay, I think if someone does not have an estate plan, if they could just have a will, I think for me, as a starting point, a will is so important, because it's one of the most important documents that one will ever draft in their lives. We spend so much of our adult life working and creating assets, and it is important that we make sure that when we are gone, what is going to happen to those assets that we have worked for. When someone dies, it can really be a source of family disputes. So if you do not express clearly your wishes, it can really cause a lot of family feud.
As we've seen.
Yes. So a will is important, and depending on what assets you have. So I know some people have not amassed a lot, so a will can just be enough as a starting point. But of course, the more assets you have, the more complex even your will and your estate planning has to be.
You know, Mama, the question that I forgot to ask, or it didn't even occur to me to ask the last time we spoke about a will, is what quantifies a will? When do we say this is a will? Because in my mind, there has to be a lawyer who says, yeah, no, that makes sense. Sign, So when is it a will? Because you can write your wishes on a piece of paper, and then someone finds it after you have died and says, this person left a will. Or you just left a piece of paper. So when is it validated as a will?
Okay. In South Africa, we have the Wills Act, which is a piece of legislation which clearly stipulates what should be included for a will to be valid. So we talk about validity. So your will has to comply with certain things. So as a definition, a will is a legal document where you as an individual will express your wishes as to what happens to your assets when you pass away. So the first thing, when you draft a will, you must be above 16. You must be of sound mind. For example, you must not have mental illness, anything that will affect your mind. You must not be drunk and so forth.
What happens if you don't know that you are actually having or experiencing mental health challenges?
Well, if there's anyone who is going to allege that you were not in your sound mind, they would have to then prove. Because remember, even if you are mentally ill, you are not always going to be of unsound mind all the time. You will have what we call lucid periods where sometimes you are normal. So in those situations, it actually becomes difficult to say, this is at the moment you are not in your sound mind. So if anyone wants to dispute the will based on the fact that you drafted your will when you are not in your sound mind, then they have the onus to prove.
Because I was gonna say that we live in a country now where people are very aware of mental health.
Yes.
So we have a lot more diagnoses, of mental. Everyone now is getting diagnosed with something: depression, anxiety, like a lot of things. So that's why when Mama said mental health, I was like, then a lot of us are in trouble, because a lot of people have formal diagnoses but are living normal lives and have sound mind. I'm gonna say most of the time. Most of the time.
It has to be something that is going to affect your thinking capacity. If you are depressed, that does not disqualify you from drafting a will.
Oh, wow. Okay.
Yes. Then the other important thing is that the will must be in written form.
Not typed.
No, it can be typed, but it must be a document. You can't have an oral.
I can't leave a voice note.
Yeah.
But with a voice note, you can say it's memes.
But with AI, people can manipulate that. I don't know if that's the reason, but...
this probably happened before AI. The legislation.
But there's AI now.
But with a voice note, you can tell, no man, this is this person's voice.
But
and they sound fine. They sound like they have sound mind.
We've had court cases where people have drafted a will and left it on their laptop. But as long as there is maybe a code or something, we've had court cases, and the court would have to make a determination whether it has complied with the requirements of the Wills Act. So, because that is key. And the other thing I've spoken about, it must be in writing. You must be above 16 and in your sound mind. And it must be witnessed.
By anyone?
Yes. If you are going to inherit, then you are excluded. You are disqualified from being a witness, unless if you are qualified to inherit interstate.
What is interstate, ma'am?
Interstate, it's where someone dies without a will, but they are closely related to the deceased person. And in terms of Interstate Succession Act, we have a predetermined formula of who should inherit. So, for example, a spouse, children.
Okay.
Those are examples of people who must inherit. So, if you qualify to inherit interstate, then it will be an exemption. But we prefer that you have independent people witnessing. And remember, with the witnesses, they do not need to know the contents of the will, because remember, your will is your private wishes. And I always say to people, do not be scared of truly expressing your wishes in your will, because when the will is read, you are not there to answer any questions. Because remember, when you contest a will, it's very difficult to contest a valid will. because you have a right. In South Africa, you have a right, what we call freedom of testation. You can do whatever you want with your assets. That's why sometimes people say you can even disinherit your own children as long as they are adults. But if they are minor children, obviously they will have a claim, a maintenance claim against your estate. So obviously there are a number of things that limit your freedom, but I can talk about it later. So your witnesses do not need to know the contents of the will. They must be above 14 years of age. And I also recommend that at the end of the will, you need to write the details of the witnesses. So, for example, should there be a dispute, you can always call the witnesses. So, what the function of the witness is just to attest that the testator, that's the person who has written the will, and who has signed the will, they are confirming that it is indeed the will of that person by putting their signatures.
I just wonder what happens when everyone involved in signing up that will gets to just die at the same time.
In a car accident, it's like the witness, the person.
It can be, I don't know.
Look,
It's not impossible. It's really not impossible.
Look, the sole function of the witnesses is to just confirm that the signature on the will is that of the testator. So we only call upon the witnesses if there is a dispute. Someone is challenging the validity of the will. Otherwise, they don't serve any other function. Yes.
I also want to go back to what Mama said, that because we live guys, you know, we live in South Africa, and there's a lot of people that are not a part of their kids' lives. So if they are minor, meaning under 18, they can claim they can contest the will, basically.
I wouldn't call it contesting. They will have a claim. So let's say, okay, let's look at the two scenarios. If you die with, you leave a valid will, obviously you are going to say in your will what you want to happen to your assets. So if you have left out a minor child, your minor child, either a child born out of wedlock and you did not include, if they are still a minor, they will have a maintenance claim against your estate. If you die intestate without leaving a will, a valid will, your estate is going to be distributed in terms of the Interstate Succession Act. And it doesn't matter whether you have been born in a marriage or you've been born outside, or whether you are an adopted child. All your children are of the same status, and they should inherit from your estate. So they will be covered in terms of Interstate Succession Act.
I wanted to also go back to incapacity, right? So say the person is, permanently incapacitated, doesn't have capacity permanently. I can't say the word. What happens? Because I wanted to talk about the power of attorney and how you choose that and why that is important. Say the person is permanently incapacitated. There we go.
Okay. I think let's just clarify, we have two types of incapacity. We have the physical incapacity. So if I am now paralyzed, but my brain is still functioning, I can still write a will because there's nothing wrong. I can attend to my legal things. I can make decisions for myself. There's nothing wrong. I won't need a power of attorney. The other incapacity is due to mental health, where now the person is unable to make decisions for themselves because they have a mental disability issue. So in that case, You can have what we call a curator, where now someone will have to make an application, a close relative. It can be a spouse or a parent or someone close. They would have to make a court application so that they can be appointed as a curator to deal with their financial issues, legal issues, and so forth. A power of attorney, normally, it's when you appoint somebody to do things on your behalf. Or maybe you are out of the country and you are not available. So you can then appoint through a power of attorney, giving the powers to do certain acts on your behalf. So there's a difference.
Okay.
Yes. So let's say, for example, I'm out of the country and I want to sell my property. Then that will be a power of attorney. I can appoint somebody to say, you are going to deal with the sale of my property, and that will be called a special power of attorney for a specific function.
Is it the same
But
as an
if I am, sorry?
Is it the same as an executor?
An executor is a person who is appointed in a will to deal with your estate when you pass away.
In the will.
In the will.
So power of
So
attorney,
we
you are
have two
still
types. Yes. So
Okay.
power of attorney,
Okay.
when you are alive, you are only temporarily maybe unable to do something. You can then appoint a person.
Yeah.
And if it's permanent?
If
Happens a
it's-
lot with
You are
buying
alive, but
houses,
it's
ne?
permanent.
Also,
Yeah.
I've seen it more common with buying a house. When
Yeah,
you buy
buying a house. Yeah. So it can. We've got two types of powers of attorney. The first one is a general power of attorney, where you can say, I want you to maybe deal with my financial issues. So it's almost like a blank kind of power of attorney. But we also have what we call a special power of attorney, where it's for a specific activity. For example, like what you have correctly said, buying a house. That will be a special power of attorney. Then an executor is a person. Remember, when you die and you have assets. When you were alive, you were dealing with your assets yourself. Now we are not there anymore. So someone has to be appointed to take over and manage. We almost say they will sort of fall in your shoes and manage the process of winding up of your estate until the assets are then given to the beneficiaries. So we've got two types of executors. There's the one that is appointed in a will, where you choose the person that you want. Then we have what we call an executor dative. That one, if you die without a valid will, then the master of the High Court will then appoint an executor. And it might be someone that given the opportunity, you'd not have wanted. So normally what happens if someone dies without a will, when you are now trying to register that estate with the master, depending on the value of the estate, if it is less than 250,000, all your belongings are less than 250,000, then you go to the magistrate court, where you will be assisted. And then a letter of authority will be issued, and a representative is then appointed to manage your assets. But if your estate, the value of your estate is above 250,000, then your estate needs to be registered with the master of the High Court, and an executor has to be appointed.
Oh.
So the family will have a meeting where they can nominate, but the master still has a final say in appointing that person. But if there are disputes and the family is not agreeing who should be the executor, then the master can then appoint any of the family members
Yo, bazo appoint lo
Yo.
antosile lo.
What means
But it has
that
to
one,
be someone
that one
quite
will tell the money.
close. So it has to be someone close in
Like your
terms
spouse,
of
your
your
kids.
children. Yeah, if your children are adults, then you can appoint the adult children. Depending.
What's a proxy? I don't know. Is there something?
A proxy is normally what we use, for meetings. If you cannot attend, let's say you are a board member and you can't attend a board meeting, then you can give someone a proxy. Yeah.
Yeah,
So
there's so many
it's
terms
little-
I'm learning. today.
It's something.
I want to go back, Mama, to your family communication. Just the thought of it. There's a show actually that plays on Zanzi Magic, and after people die, Mama, there are disputes.
Yes.
There are disputes. People are taking cards that don't belong to them, and because there's no will, right? So how can someone successfully make it comfortable for people to be okay with communicating when it comes to estate planning before they die? How can they, the person do they, like you said, they don't need to actually tell anyone, right? But say they do want to tell someone, what is the role of just family communication in terms of estate planning?
I think it's important to have a will. If you have a will, you are going to solve a lot of family disputes.
Mama, can you imagine? I think I'm your favorite daughter, and then the will comes out, and you've left everything to that person that doesn't do anything with their lives. It's the start of a war.
It's not about favorite. I don't think it's about favorite daughter. It's about who's at what way. You being the favorite daughter, maybe you might be successful. Then when they were drafting the will, they were like, this one is fine. Pushing here and there. Probably, I don't know. I'm thinking along those lines.
Yeah. Because that's why I'm basically asking, is it important to communicate to your family with your estate planning?
Okay. It depends. If it's a spouse, obviously would recommend that you discuss. And once again, depending on the type of marriage, if you are married in community of property, you will have a joint estate. So it's important that the spouses discuss, because when the one spouse die, we will deal with the whole joint estate. Yes. Oh yes. Because remember, you have
with
one
even my
estate.
estate while I'm
yes,
still alive.
while you are still alive. So we will look at all the assets that you were owning with your spouse. If you are married in community of property.
Even
so
though they are alive.
Yes. And
People.
yes. And even the money that is in your bank account, personal bank account, it forms part of the joint estate. So remember, when marriage in community of property, it's a joint estate. So we will then look at all the assets, we look at all the liabilities. Only after all the liabilities have been paid and the administration costs. Because remember, during the winding up of the estate, there are costs, like your advertising cost, paying the executor. They are paid a maximum of 3.5% of the value
Even
of
if it's
your
a family
estate.
member.
Yes, they have to be paid. Yes. So if it's a family member who has been appointed as an executor, it is a rule from the master that an agent, an attorney, then takes the role of an agent to assist, because a family member, they don't know the law. Because when we are winding up an estate, we are guided by the Administration of Estates Act. And someone who is not legal will not understand. So a lawyer, an attorney has to be appointed as an agent to assist that family member who has been appointed as an executor. So the other issue which we are seeing, especially amongst the African families, we have the customary law and
I wanted to ask about
clashing.
lobola.
Yeah, clashing. Because remember, we are coming from a culture where your firstborn son would inherit But in our African culture, you were not inheriting for your personal benefit. You were almost like an executor. You take over the family assets, you manage it, but for the benefit of the entire family. But now you have people who want to then abuse, or who were abusing that culture. Then they come and take the assets for themselves, and it was causing a lot of hardships. And that's why now the government came up with this Interstate Succession Act. And if I tell you, it has solved a lot of family disputes now. So even if you die without a will, the Interstate Succession Act kicks in. And it is very clear in terms of who should inherit. Because if you do not exercise your right to write a will, then this piece of legislation stipulates who should get your will. So for example, if it's an adult, the first thing we look at is, are they married? So if there's no will and they are married and they die, then everything, if there are no children, everything goes to the spouse. So in the olden days, you would have now the mother-in-law crying because they would expect that they are going to inherit from their son, but not anymore. So everything goes to the spouse, the surviving spouse. Then if they have children, you are married, you've got children, then your estate will then go to your wife and your children. Sure. So depending on whether you are married in community of property or not. So if you are married in community of property, like I said, we have to deal with the joint estate together. Only after we have subtracted the liabilities, what will be left will then be divided by 2. Then the half of 50% belongs to the surviving spouse. Then the other 50% is the one which will need to be distributed either according to the will, if there's one, or according to the Interstate Succession Act. So if there is no will, now we are talking of Interstate Succession Act. The surviving spouse, you are married in community of property, you will have what we call a child's share on the 50% of the deceased spouse. Right? So how do we calculate this child share? We take the total number of children of the deceased, whether born within the marriage or out of wedlock, or whether they are adopted, it doesn't matter. So the total number of children, then we add the number of spouses. So if there is one spouse, it will be the total number of children plus the spouse. Then we take that number, we use it to divide into the total value of the 50% of the joint estate. So if that amount is less than 250,000, because currently that is the gazetted amount, 250,000 will go to the surviving spouse. Then whatever is then left gets divided equally amongst the children of the deceased. If that child share is above 250,000, then each, the surviving spouse and the children, will inherit equally.
Sure. You know what I'm confused about?
What I want to, just before I lose my thought. So what is important is the 50%, if you are married in community of property, you do not inherit it. It's yours by virtue of the marriage. Now we are just talking about the 50% of the deceased spouse.
That you might still inherit from.
Yeah, you get what we call child share, which is what I've just explained, how we calculate it.
So, Mama, what if the liabilities of the deceased are more than 50% of the joint estate? Now they're eating into my 50%.
Yeah,
no,
you're
remember,
part of the joint estate.
But I'm not the one that they're not my liabilities.
No, remember.
So now it's our liabilities.
Yes.
Yeah,
Yes.
and also
Yo, that's so stressful.
with the part of the spouse, I know there's a lot of people out there who are still having spouses that they don't know of because of the lobola issue. A
Yes.
person can be in this
People don't
relationship,
divorce.
and then they go, maybe it's a fifth relationship, find that all four they paid lobola, but then they moved on. So all these four people can actually claim from your estate,
Yes.
provided they come up with like a proof.
Yes. So in terms of
But now, sorry, Mama, to add to that, is it then joint? Because agrilobola is in community of property. So does this person then have in
Four wives,
community
five
of
wives.
like in community of property relationships with 4 people or 5 people?
if we look at in terms of customary law, polygamy was almost like out of community of property. It is difficult to have a polygamy in community of property.
Remember,
So
Mama, this
in the
person
olden
moved
days,
on.
in the olden days, you'd find a man will have 5 wives, but each wife will have their own house with their own personal assets. Then the husband will have his assets. So in the event when the husband dies, it will only be his assets being distributed to the wives and the children. So in terms of customary law at the moment, it is only the males who are allowed to have more than one spouse. Although this might change very soon with the new law coming, because women are challenging that it is unfair. Why should only men be allowed to have more than one spouse?
Karabo from generation done.
Yeah.
Polyandry is about to get legalized.
Yeah, now we have different forms of polyandry and all those things
We have so
that
many
I can.
polys, like,
Yes, but it is very important for people to understand that if you are married in terms of customary law, it is important to register the marriage.
Oh, okay.
Yes. So you have an option to go and register it as a customary marriage, or if you marry the same person civilly, then you can register a civil marriage. You are getting me? Right. But now, if you are married customarily and you have complied with the requirements of a valid customary marriage in terms of the recognition of Customary Marriages Act, and you do not formally divorce, that spouse will still remain a wife.
Spouse.
A
A
wife.
shareholder of your assets.
A wife.
Sure.
So now you have a situation where you are now married to somebody else and you have a joint estate, like I explained. After paying the liabilities and the admin costs, whatever will be left will be split into 2. Then the 50% of the deceased spouse will then be distributed amongst the spouses, and the children. So she can come and claim that I am still
His wife.
his wife because there is no divorce. And if evidence is there that is, the whole process was negotiated and concluded.
Oh, so it
And
has
she's
to be
a-
concluded.
Concluded, yes.
Concluded
terms
in
of-
what way? Like concluded
There has
in
to
like
be a
the full.
celebration.
So it's a negotiation, conclusion, and celebration. In terms
If you go
of
Ali,
the customers. But
Somebody-
remember now in South Africa we have how many tribes? More than 11 tribes with the different customs. So it has to be done according to your custom. So if you are marrying someone who is coming from a different tribe, the family will need to agree beforehand to say at what point of the process are you going to consider you as the makoti of the family.
Officially.
To say now there is a valid marriage.
So if it's if suppose you pay 10 rand out of 50,000, do they still have suppose like I'm speaking of a person who was moving from relationship to another, having to pay lobola, but not the full amount. Maybe just the
Like they came to knock nyana, they
knock nyana, left 10 rand nyana, and something.
Because
like
apparently
that.
you're married when you do that.
Yes.
Apparently.
The validity of the marriage is not determined by the lobola payment. Not at all.
Yeah.
It's
I think a lot of people are going.
Remember, I said it's about negotiation, conclusion, and the celebration.
So if there's no
So if
celebration,
you look at
you're not a wife.
the recognition of the Customary Marriages Act, it doesn't say the lobola must be paid in full. So the actual payment, the money, it's not
A factor.
Yeah, it's not a factor when we talk of who validate. So in terms of the customary law, even if you were poor, you can be validly married customarily. The two families will come, sit down, negotiate, agree on a price, and the mkwenyana says, but I do not have money. I know this is the amount that I have to pay for the lobola, but I don't have. And the family will then ask for the makoti, then you conclude. Because once you have reached on the amount of the lobola, you have agreed, you have concluded. Then you request the makoti to be handed over to the groom's family. There is a celebration. You are officially the makoti, regardless of what has been paid. So the payment of the lobola is not a factor when we look at the validity of the marriage. Because also in some cultures, bati umfati akaqedwa, the lobola. You can pay.
But you must live, I think, from what I know, especially in the Swati culture, you must leave something, even if it's 500.
Yes.
So that you keep the families having to say, hey, we are
Yeah,
that's why it's like a normality in the Swati culture to
Guys,
say.
can we
So
finish
they
things?
are.
Can we just wrap up things? Also, Mama, I just want to find out, so say the person like Ace made an example, just has been knocking, leaving 10 rand, what, or has maybe finished the lobola negotiation celebrations and they're all valid, and then they get civilly married after all of that. Does that supersede the customary marriages?
Okay, if you start with the customary marriage and you do not divorce, then you go on to marry civilly somebody else. That civil marriage is null and void if you go to the act. So the advice here, before you get married,
So remember, the civil marriage is null and void because you are customarily.
Yeah, then you'll be considered
Guys, please
as
go to court and go
customary, the second customary wife.
So the one with the rights is
Both
the first.
You
you'll be spouses.
You are mamngani. You are mamngani.
You are now
both
regarded as customary wives.
Who doesn't exist.
Yeah, but
But if you start with a civil marriage, right?
So, Mama,
and
null and void means you are not married.
No, you are not. The civil marriage is null and void, but
so
you are still a wife
customarily.
in terms of the customary law.
Even if you didn't do the lobolas, you just went to go sign.
Remember, when we say lobola, we talk of marriage, we are assuming that some negotiation was done. Because there's a difference between a side chick. A side
No,
chick
say we didn't do lobola, we decided we are eloping, we are going to go sign.
But then there's you sign what, civilly?
No, you sign at Home Affairs,
But remember, when you sign at Home Affairs, the civil marriage, lobola is not a requirement.
Yes. So, are you still a customary second wife?
Wait.
I think we need an episode on just marriage.
But can we finalize? This one is very important because a lot of people need to go to court. They need to go to Home Affairs after this to just make sure.
Let me just clarify. Maybe if I say, in South Africa, we have 3 types of marriages. Let me start there. The first one is the civil marriage. This is the one that you go to Home Affairs and sign. Lobola is not a requirement. You just need to, in terms of the Marriages Act, you need to be above 18 years of age. You need to give consent, and the marriage is conducted by a marriage officer, somebody who is competent to marry you. So there's no talk of
And you
lobola.
don't need witnesses.
No, you do need
Okay.
witnesses. Right. Then the second type of marriage is the customary marriage, which has to comply with the requirements of the Recognition of Customary Marriages Act, right? Which you must register at Home Affairs.
Okay.
So when you go to Home Affairs, you are not getting married again. You are simply registering the marriage. Because that marriage certificate acts as a what we call prima facie evidence that you are married customarily. Okay? Number 3, we have the civil union, which is regulated by the Civil Union Act of 2006, which regulates marriage between people of same sex.
Okay.
Yes. So those are the 3 types of marriages. Now, what happens if you start with a civil marriage, right, and you do not divorce your wife, then you go and pay lobola for another woman. This second marriage is null and void because the civil marriage does not allow more than
Polygamy.
one spouse.
Oh, makes sense.
Yeah. But if you start with a customary marriage and it is valid and you do not divorce, then you go and marry somebody else, another wife, a civil marriage. The civil marriage is invalid, but if you've paid lobola, then there is a valid customary marriage. Now you have 2 spouses. Yes.
I wonder what's going on
I
in your
hope
thoughts.
I have clarified.
I think this is gonna need another episode. I
think
this
we
is gonna
need to
need a
just-
whole episode because
Yeah,
but guys
about
go
marriages.
to Home Affairs and just go check your affairs and make sure that check your marriages because So Mama, what I want to know also, just going back to estate planning, I think the marriage thing just shook me. What are some of the strategies that people use in their taxes when they're estate planning?
Okay. With estate planning, we try to arrange your assets so that you can minimize taxes. We've got different types of taxes. You've got income tax, which is each time you get an income, of course, you have to pay to SARS after certain deductions that you are allowed. Okay?
Then, before you continue, Ace, have you looked at your taxes? Have you actually had a look at your taxes? Have you sat down and actually looked at your income tax?
It's complicated.
Please try it. If you want heartbreak, gonna be heartbroken.
Yeah.
Exercise just looking at how much
income tax. But remember, income tax is on a sliding scale. The higher you earn, the more you pay.
No, it's
a sliding scale. It's a sliding scale. With the lowest being 18% and the highest being 45%. But there are certain deductions.
45%?
Yes.
That's of your pay?
Yes.
Isn't it
that's
different
why the rich don't
from
pay
personal
taxes.
to business?
Yeah, that's why I said we've got different types of taxes. We've got personal tax, there's business tax. Currently, it's 27%. Then, your trusts are also taxed. Yes, we say it's nice to have a trust, but a trust has got also positives and negatives. And one of the negative things about a trust, it's the tax, which is a flat rate of 45%. But there are ways of mitigating that, which when we talk about trust at a later stage, we can go into detail. The other taxes are your capital gains tax. And whilst I'm talking about capital gains tax, a lot of people do not realize the impact that capital gains tax has. For example, if you have a property, a house, when you dispose of that house, either you sell, you donate, or it's inheritance or whatever, it will attract capital gains tax. So what happens, we look at the value at the time when you dispose your property and the value when you acquired the property. And of course, there are certain things you are allowed to deduct. I won't go into details, but the proceeds now, if it's your primary residence, the house that you have been living in, the first 2 million gain is exempted. But if it is a second property, you will have to pay capital gains tax.
I feel
But
like my
that
face
tax
has been
is
going
not
a
a
lot.
standalone. The gain will then be included in your income tax, and then you pay at your tax rate. But it's complicated. But I think I've just give you the way. So capital gains, your shares. A lot of people have got businesses where you start with a zero or with a loan which you give to your business to start your business. But remember, you have shares, and when you die, someone is going to take over your shares. The value of your shares will have grown. Shares attract capital gains, please. And I think people need to understand this. And that's why when you do estate planning, you need to have sufficient cash. Otherwise, you'll be forced to sell those shares to have cash. So, for example, if my business is now worth 100 million, I'm the sole shareholder in that company. Can you see the gain? And the capital gains tax becomes a problem. But there are other ways of mitigating that. So, for example, you have a trustee being a shareholder of in the company. A trust does not die. So can you see how it will then affect that?
And charities, I know a lot of, because
Yeah,
apparently the
charity.
rich
If
don't
you
pay
donate,
taxes.
if you donate to charitable organizations, they are also exempt from any tax.
Do they have to be registered?
Yes, it has
Charity.
to be. Yes.
So you can't
and
go to
they,
Mom's
and
Kosana's
qualify.
crash.
No. They have to be registered and qualify as a charitable organization, NPO.
So if I'm
Right.
really giving stuff, Mama, if I'm saying going to orphanages, but there's proof, but the orphanages are just not registered, but there's proof that I'm giving and...
Otherwise, if there's no proof, anyone can then try to sort of...
go around it.
Yeah. So it has to be properly
registered.
NPO. Then you also have estate duty. I think I did mention a little bit last week, the estate duty, that's your death tax. So if your estate is above 3.5 million, you will have to pay anything that is above 3.5 million. After we have deducted, remember, we have paid the liabilities, we have paid all the claims against the estate, we have paid the administration fee. What is left and it's above 3.5%, then you have to pay estate duty, which is 20% up to 30 million. Anything above 30 million, it is 25%. So there are various ways in estate planning where we can mitigate that. So let's say, for example, your children are now done with the school, you have accumulated a lot of assets, you can start giving away your assets, donations. It's also one way of planning your estate and reducing your estate duty. If you are married, currently anything that is inherited by your spouse, you do not pay estate duty.
Mama, just say that again, please, so we just make sure that we get it. Anything that is inherited
by a spouse, a surviving spouse.
So you know, a lot of people make their spouses the chair people of their foundations and what, and owners of foundations, and you must actually look at it. Look at I can't say names, but there's a lot of there's a lot of, and internationally and nationally, there's a lot of
So whether your surviving spouse inherited through a will or through the Interstate Succession Act, anything that goes to a surviving spouse currently as the law stands, it is exempted from death tax, the estate duty, in terms of Section Q, 4Q of the
Including a
estate.
business.
Yes, anything.
Guys, leave
So
your
you
businesses
can leave
to your
100
wives.
million to your spouse, so you won't pay any tax. It is only when the surviving spouse then passes away, right?
Then can you
Then
say
you pay.
you can maybe say donate it to your foundation or your trust or a
If it's-
charity?
Yeah.
And
If it's
still-
a trust, the surviving spouse has to be a beneficiary for it to qualify.
Say both people now have passed.
No, we are talking of the deceased spouse.
Yes.
Yeah. If he leaves everything to the surviving spouse, who is a beneficiary of a trust, so he leaves the assets to the trust where the wife is a beneficiary, they need to be exempted from estate duty.
But as soon as it's the kids, then
Yeah, the kids' portion they pay. They
Do
pay
Muslims
estate-
pay tax?
But
What?
remember,
Do Muslims pay tax?
how
I'm not sure.
Even me, I'm not sure.
I'm
Do
not
they
sure.
even contribute to it? They
Who
don't.
are Muslims? Who are you talking? I know that I know what you're asking, but what are you actually asking? What are you asking?
I'm asking because when I don't know. There's Muslims don't get interest or something like that.
Yeah, in terms of charity, but I
They
have
don't-
no
Charity.
knowledge. I have
They
no
don't
knowledge.
accept
Yeah.
interest. Yeah.
So
From who?
The-
They don't accept interest from like the bank.
Yes.
They say no, don't give me interest.
I think we must just be careful when we start talking of
Yeah, that's what
religion. It's a sensitive topic. Let's stay away.
Yeah.
I'm so curious, but we're gonna stay
No.
away.
I was just asking from the
From
legal
the
side,
side.
but I'm
And,
definitely sure that they're not allowed to receive tax or something like that. Not tax, interest.
Yeah, I
Interest.
know.
Yeah.
But they have certain banks and so forth.
their own
they've
banks
got
So it's a
and-
lot more
yeah,
complicated than-
complicated.
Yeah, I think let's
let's
shy away from. Yay, when I will get
Yeah.
people will come after.
And then the other, we've spoken about estate duty. And the other thing I just want to draw to your attention, if you have life policies, and you have nominated beneficiaries, they do not form those proceeds from your life policy will not form part of your estate,
Oh.
only for estate duty purposes. Then whoever is a beneficiary, they would have to pay a pro rata proportionally to what they have received. Right?
They pay to who? To the estate.
No, to SARS. Tax is paid, so the executor will have.
SARS is so stressful.
Yeah,
It's
so
everywhere.
SARS, you can't run away.
And the last time you said you pay when you're dead also.
Yes, yes.
Like
that's
that's
the
you are
estate
alive,
duty
you
I'm
pay,
talking
you
about.
work, you pay, you.
Yeah, so remember, inheritance, it's giving away your assets. So you either give away your assets when you are alive through donations, and you pay donations tax, but every year you are allowed 100,000 is exempted, which
To
you
do
can
what
give,
now?
you
Which
can
can go
donate.
away.
Yeah, which you can donate. Anything above 100,000, you start
It's
paying
taxed.
20%, up to 30 million. So you either donate your assets when you are alive, you donate, or
When you've passed.
when you've passed on, it's through inheritance. That's why the tax is the same, the rate. Donations tax and estate duty tax are exactly the same, because you are giving away your assets. The only difference with the donation, you are giving away your assets while you are alive. Inheritance, you are giving away your assets after you pass on.
And life insurance, technically, you're not giving away your assets because it's not.
Remember,
yours yet.
life policy is not an asset whilst you are alive. It's not an asset.
But once you pass,
But once you pass away, it is called a deemed asset. Right?
okay.
And like I said, if you have nominated beneficiaries, then the money just goes straight to the beneficiaries.
Then they
It only
get
forms
taxed.
part of your estate if you do not nominate beneficiaries.
So you
Because
can't
then
put it in
there's
your
no one,
will.
then it comes to your estate. So that's why it's
Okay.
very important if you've got life policies, you've got a pension fund or retirement annuity, to make sure that you have nominated beneficiaries. Otherwise, that money will then come to your estate, and it must go through the whole process of winding up an estate. And depending if there are disputes and fights and complications, that can take a very long time.
Ma, I was going to ask actually, how long does, say, a very simple case of estate winding take?
If there are no complications, the time
I
frame
like the way
is,
you're saying if there are no
Yeah,
complications.
like a simple one. Like, person died, there's a will.
6 months is what we are given by the Master of the High Court.
So these people have
6 months.
no access to their assets for that amount of time.
No, if there's a will, you can make a provision. You see, that's the nice thing about writing a will. In your will, you can even say during the time that the estate is being wound up, I would like a monthly sum as maintenance, payment to my children or whoever for their upkeep until finalization of the estate. So in the event that the estate takes forever, you have made those provisions. So in a will, you can say
Write
anything
anything.
as long as it is not against the law, illegal. You can say anything.
What is illegal? What is
For example, or if you put a condition which is contrary to our constitution. So, for example, if you put a clause to say my daughter can only inherit if she divorces her husband.
No.
But
Is that illegal?
I'm just giving as an example that
Well,
would
it's
not.
your-
If I don't
It's
like
your-
the
it's your-
husband,
it's your
why is he getting my
opinion.
money?
It's your
So for
But I
opinion.
don't like the husband. Why is he getting my money? I get my money. I
Yeah,
can
but you are
decide to get
putting now a condition to say your daughter should not inherit.
rights, your
Until
daughter's
now,
rights.
they're in
Until he-
community of property. If I give, it means I give to both of them. I don't want to give
No,
to both
there's
of them.
I think you must understand me well. I'm saying if you put a condition where now you are excluding your daughter to say, or putting a condition to say she can only inherit if she divorces. So you are now saying if she divorces her husband, then she will inherit.
Imagine you are directing
No,
that
I
from the
understand
state.
Mama well. I just don't see why that is illegal.
You are even
But what
directing
you,
that.
I
Just
think,
as an opinion. Like,
I think what you are talking about is the spouse benefiting. So what we normally
Yes.
do in a will, we can put a clause to say whatever my children or my heirs inherit, it should not form part
There we go.
of a joint estate.
See,
Yes.
that makes sense.
You
to
can
me.
put a provision.
We've been fighting
So
all our
that's why
lives and you want to eat my money.
it's nice
No.
to write a will
Properly.
to protect. So even for your spouse, if you leave everything to your spouse, you can also put a clause to say it is, if she gets married, whatever she's inherited from your estate should not form part of.
But you can't take it. You can't say you must donate it. Whatever's left, donate it. You can't say that.
No.
No, my
But I
be
mean,
sure.
it just remains
Yes.
her asset. Obviously, if it's a house, she can stay there with her new husband, but he is not entitled. Like, should they divorce, that asset will not form part of the joint estate if they married in community of property. So there are various ways, and this is all part of estate planning to protect those assets.
And what's the difference? I think like a lot of people get confused between life policy and a funeral policy, because one thing that I've seen in most cases is that like a person would live like a funeral policy. I mean, that's to actually bury them, right? But then there's families who actually fight for that, like
Hey,
that amount.
that 20,000.
Yeah.
Whatever amount, like I just want maybe clarity
Okay.
on that, yeah.
Yeah. The difference between a life policy and a funeral cover. A funeral cover will cater for the actual funeral. So it's a specific amount which is paid to cover your funeral expenses. So depending on the company, some companies, they will provide with the transport, they provide you with the coffin and so forth. Some even with whatever the tent and grocery money. So there are many different types of funeral covers depending on what you want, and you can determine the amount. With a life policy, it is a policy that you take and you enter into a contract with the insurance company for a specific amount of money to say, in the event that I die, this should be paid to my nominated beneficiaries of the policy. So it's a contract. But we also have policies where that amount increases depending on the type of policy you have taken, where you also increase your your monthly payment with an escalation, because remember, inflation affects the value of money.
Yeah.
You can take a life policy today for 5 million and you think, 5 million is a lot of money. If you don't increase that amount, in 20, 30 years' time, when you die, 5 million is really nothing. So people must just be careful when they take life policies to make sure that that amount is increasing as your contributions are also increasing, so that at least it's something worthwhile. So it is a lump sum that will then be paid to your beneficiaries.
I just want to ask just one last question before we move away from the life cover. I know that if you die in a certain way, say if you take your own life, like there's a clause in most life covers where then your money doesn't get paid out.
Yes. So when you take a life cover, please make sure whoever is selling you that policy, they have explained the terms and conditions. And when you get that document, make sure you have read and understood. So yes, suicide is an exclusion in most of the life policies. So you must be careful. And the other thing, if let's say inheritance, if you kill the deceased person that you are supposed to be inheriting from, you will be disqualified if there's
that
evidence.
Makes sense.
Yeah.
If you kill who?
If I kill you and I was supposed to inherit from you, I can't inherit.
And there's evidence.
You're gonna go to jail, most.
But you also get to become disqualified from inheritance.
Including my descendants as well.
No.
Say it's my mother and I kill my mother, but she had left stuff to me and my children. Do I get disqualified as a person or just my entire family?
As a person.
As a person. Okay. It's very important.
That makes sense. And with this, having to also tell people that I nominated. There's a lot of rosemary.
You mustn't tell people.
You know rosemary.
Don't tell people. Don't even tell people they're beneficiaries of anything. Life cover, your will. Just don't.
Yeah, that's why we say your will. You must make sure that you keep it safe. The only thing that you need to tell people is where to find your will.
And if
because
they find
it must be found.
If they find it prior to me dying.
Well, depending if they've been excluded, they might feel unhappy about it, but they can't force you to put them there, because remember, a will is your wish.
So the last question I want to ask is, when is it valid to take a changed will over an already existing will?
Okay.
Say I'm in hospital and my husband actually, I realized that I might be here because of this man, and I change my will.
Okay.
But I change it there and say I pass on, and there was a witness. Does that stand as a new will?
All right. So each time that you write a new will, we always put a clause, what we call a revocation clause, to say I now revoke any will that I have previously written, and that has to be expressly written in the last will, because we will only look at the last will. Now, people must try not to have these wills written on your deathbed, because these are the wills that are usually the majority of the wills that are contested.
And if I'm of sound mind, I'm just on my
Yes.
deathbed, but I'm just
Because
I'm of sound
then
mind.
the question becomes, why all of a sudden did you change just before you die? Was
Because
there
you tried to poison me.
duress and all sorts of things? So you are opening yourself to having your will being challenged. I'm not saying
You
it
could be on
cannot done.
gunpoint also, you know.
I'm not saying
But
you
also,
cannot.
can you imagine you find
but
someone
yeah.
did something to you, and then they in your
Yes,
will, and you're
it's
on your deathbed, like
it's within your right, but then you must make sure that will complies,
and
because
have a witness and
have your
everything.
2 witnesses and so forth. I mean, I've done a will when one of my client's mother, she had cancer, and so I was called as the commissioner, because now so it has to, there are certain requirements. If the person does not draft the will themselves, then there must be a commissioner of oaths, there must be 2 witnesses, and so you have to but people must just be very careful, because those types of wills are prone for being contested, because someone is going to be unhappy.
There's a legal will. What about God's will?
Yo, Portuguese. Yeah. Today your questions. But I think what I've learned a lot from, the 2 sessions that we had with Mama is we need to educate ourselves, especially about daily proceedings of life. Because I've learned so much.
I've also learned about
You know what I mean? But these are things that affect us. But we just don't know enough about them. Mara Instagram, you know what I mean? Like, we need to really take time to learn about the proceedings of our life during and even after life. Because, you could be putting people in a very tricky situation.
And especially as young people.
Especially as young
it's
people.
very important to plan ahead.
Plan ahead when there's Gucci. I love it.
See, life is, we don't know. Although death is certain, we are all going to die.
But we don't think that, eh? I
But
promise you.
The only thing is we don't know when and how. And sometimes the dying process can be protracted and leaving the family destitute. I mean, imagine if you've got cancer and you don't have a medical aid, and the cancer treatment is very expensive, and you are sick for 2 to 3 years, and money is just going, paying the bills, and by the time you die, there's virtually nothing. And sometimes you don't die, you become incapacitated, and you still need to eat, to pay rent, because those things do not stop. Your children, they still need to go to school. So, so you need to plan about those eventualities.
And they're also like it is like also like an uncomfortable topic to talk about.
Yeah.
But one thing I've realized with us, the black people, is that like we don't have access to such information. I feel like maybe such things, they could, maybe some basic subject that we do from high school being it facilitated also to varsity.
True.
Or maybe colleges for that matter.
Yeah, I know with many universities, in your final year, they normally call
PPAs.
financial planners from different insurance companies, and they do educate. I know also the Department of Justice, they have a Wills Week, which is usually around August to September, where they partner with the attorneys, and they go out in various communities to give people, education and draft wills for free. Then we also have organizations like banks. Banks normally also draft wills for free. right? And then, some insurance companies, if you take a policy with them, be it a life policy or whatever, they also can assist you with in drafting a will. So, yeah, it's very important that people must be made aware through this educational talks.
So the one at the bank is also as valid.
Yes, because they have some of them have people drafting within the banks, and some of them have lawyers on their panels who draft the wills.
Sure, Mama. I think today, it gave me heartache, heart attacks, heart palpitations.
Yeah.
I mean, this conversation honestly was, it was very triggering, because it's very uncomfortable. But it's a reality of a lot of people, especially families, especially when thinking about family dynamics. It's a lot of people have experienced, I think, the trouble of not having a will, or not estate planning or anything of that sort. So, Mama, we thank you so much for joining us yet again, for just gracing us with your presence. And I know we asked you this the last time, but where can people find you?
Thank you so much for having me. People can find me in Nelspruit. That's where I am based. But if you are anywhere in the country, you can phone me. We can set up a Zoom meeting. I have done Zoom consultations where we can discuss if there are documents that need to be sent. Technology makes it possible. So my email address, my cell number, it's 082 3595 The landline is 013 752 6364.
And your email, ma'am?
And my email is Tarwa, all one word. The Tarwa is spelled, the Tarwa is spelled TARWA @telcomsa.net.
Okay, so you know where to find Mama. Go read up, go check your affairs, and really consider estate planning and drafting a will, because even if it doesn't affect you, it affects those you really care about. From myself, Ace, and Unopa Tarwa,
Jovito.
goodbye.